we'll call the local law enforcement agency after we've called the broker to discuss kind of licensure options. So we're going to take kind of a blended approach, but what you can expect from us is typically with an audit, we are going to notify you ahead of time. We don't do very many surprise audits, and if we do a surprise audit, right away that should signal, oh boy, I'm going to be in for a wild ride with the commission. Not good. But we're going to give you advance notice, and what we're going to do is we're going to look at the files to basically ensure that you're using the proper forms and the applicable versions of the forms are being used. And we know that this is an area that we get a lot of phone calls on about, well, I just got an offer and it was written on a contract to buy and sell from 2001. Okay, they change annually. Much to our licensee's chagrin, they change annually. So if we're starting to see that you've got 2010 transactions and they're written on 2001 forms, that's going to be a little bit of an issue that we're going to need to address. With earnest money deposits, we're going to look to see who's holding it, and if it's a title company, we're going to look to see if there's a copy of the check in the file and a receipt as well. With property management, we're going to look to make sure that the accounts are titled appropriately, and we're going to look at the rents versus the security deposits. They both need to be held in a trust or an escrow account. We're also going to be looking to see if the leases are signed, if those trust accounts are appropriately reconciled, and is the accounting done correctly. And really with property management audits, there's going to be a huge factor on the financial side of what we look at. We're also, just in general though, we're going to be looking to see if the appropriate disclosures are made. Brokerage relationships are something that we see a deficiency in. If somebody refuses to sign the brokerage relationship form, just indicate that they refuse to sign and put the date on it. We're not going to force you to make them sign it because that's going to lead us down the criminal conviction realm, I have a feeling. So just make sure that you've indicated, that they refuse to sign, keep it in your file so that we know when we go and audit that yes, you tried to give it to them, they wouldn't sign it. A lot of the other deficiencies that we see are the property management addendum, those are absent. Lead-based paint, I don't understand why we continue to see deficiencies with lead-based paint disclosures. That has some pretty significant impacts federally if you violate that one. And we also see the failure to disclose adverse material facts related to radon, mold, and meth. And just so that you know, we haven't gotten as many meth complaints as we did a few years ago. And I don't think that that's because meth has gone away. But the state laws have changed. So even if you smoke meth in a property, that now falls under that statute that pretty much requires that the property be mitigated or demolished. So if you list a meth lab, don't traipse potential buyers through the property if it has not been mitigated. That is a complaint that we have seen over the years, and that's something that you just need to be very aware of. Pretty much if somebody called me to list a meth lab, I'd be running away in the opposite direction. I do know that the brokers are now dealing with the issues of medical marijuana, and what you have to think about there is the increased moisture and potential mold problems, so just keep that in mind. We are working on audit checklists so that our brokers will have a copy that they can use pretty much for their own edification. There's not going to be any surprises when we come out and do these audits unless we do a surprise audit. And the last time we did a surprise audit was because somebody was pretty much perpetrating mortgage fraud and we did not want to tip them off. But once we get those checklists finalized, we're going to post those on the website so you guys can use those pretty much for your transaction files. And I'll see financially what they can put together as far as kind of guidelines if you go through a financial audit. Because we continue to see issues with property management, one of the ways that we're looking at trying to address that issue is there's a practical applications course that's a segment of the pre-licensing education to get your broker's license. So we're working with the educators to really kind of develop courses that will address the complex areas of practice in real estate. And I'm not saying that residential sales isn't complex, but that's kind of the norm around the state. That's what a lot of brokers practice in. So we're going to be looking at the educators to do practical applications courses that address commercial transactions, agricultural properties, property management, really those transactions that a lot of brokers don't see day in and day out. And hopefully we'll be able to move away from the standard issue broker license is good everywhere. Our licensees will say, wait a minute, I don't know how to do this type of property. You need to find an ag broker or a commercial broker. Maybe I only do property management. I don't want to take on sales, whatever the case may be. We're really just trying to work on the competency issues associated with the more complex areas of practice. One of the things that we've done over the last year is we've spent a lot of time focusing on doing some internal cleanup. Part of that is looking at the different rules that are in existence for the different boards and commissions within the division to see if they're antiquated, are they obsolete. Much to not my surprise, the Board of Appraisers had 120 rules that needed to be revised. I was not at all surprised about that because really our focus with that program is trying to comply with the federal regulations. And an annual rule review is not part of their regulations. We're trying to get their cases investigated and resolved in a year. That's the big one for the appraisers. We just got done in November revising all of their rules. We're now working on the commission rules. So at the December meeting, the commission's going to have a rulemaking hearing to look at revisions to some of the rules in chapters A, B, C, and D. There's really not a lot of significant changes to those rules. There is one in particular that is going to change drastically, and that's Rule C-23, which deals with unlicensed on-site managers. And I don't know why that rule says what it says, but right now it basically says that an unlicensed on-site manager can be involved in pretty much lease negotiations. Last time I checked, that requires a broker's license. So I don't care that they live on site, they need to have a license. So we're changing that rule to reflect that. The big ones will probably come up in February. Those will be the E-rules. Those are the enforcement rules. And we'll have to address the commercial lien rule because it's not consistent with the law that's in effect right now. So we'll fix that one. But really overall, the commission's rules weren't in that bad a shape. There were less than 25 that needed to be revised. We'll also be pretty much discussing with the commission the changes to the broker's administration course at their December meeting. We're going to be covering a myriad of issues. A lot of them came up at the last meeting. The commission's going to be considering a position statement on competency. The rule failed. And the purpose of the rule was kind of to give the brokers some guidance because you have to be competent. Whether there's a rule that says it or not, there's statutes that say you have to be competent. The problem is that the statutes don't define what is incompetence. So on day-to-day, the commission doesn't operate this way, but if you had an arbitrary and capricious commission, every day they could change their standard of competency. So the rule was pretty much to kind of lay a foundation for the brokers to be able to come back to tell the commission, well, wait a minute, this is what I did to gain competency. I took courses. I reached out to somebody who does have experience in this. You know, I found a mentor. These are the steps that I took, but it failed, so we'll do a position statement that gives that guidance. But although the rule failed, you still have to be competent under the license law. They're also going to be discussing inspection issues and closing costs, because one of the things that we're seeing these days is that the lenders are saying, no broker, I don't want to see that, the buyer wants a furnace repair, just call it a closing cost, even though it's still a furnace repair. Well, when a broker misrepresents something like that, it's a misrepresentation and it's a violation of the license law. If it's an inspection issue, it's an inspection issue. It's not a closing cost. With that said, I realize that there are negotiations that go on with sales transactions where it's like, no, you've got a laundry list of things that you want repaired. I, as the seller, don't want to do them. I just want to be done with this. I want this to close. I'll give you $5 if you go, or $500 if you just go away. I'll pay part of your closing costs. There's a difference there. You're not misrepresenting something. So that's one of the things that the commission's going to discuss at their retreat in December. And one of the things that we're going to look at doing is doing a working group to kind of really wrap our arms around some of the issues that have come up with the brokers and put some guidance in a position statement. Because I know even when I've gone out and talked about this issue, it comes back to me that suddenly I've said you've got to disclose every single issue found in the inspection to the lender. Never have I said that. No. One of the other things that's coming up are indemnification agreements for real estate brokers. I see this with the appraisers. Essentially, apparently the lenders want you to be on the hook should something go south later on after the transaction's closed. You need to be really careful about that. I know that we're going to have to regulate appraisal management companies at some point under Dodd-Frank. We have until 2017. Our hope is that it will come about in 2012. One of the issues with the appraisers is the appraisal management companies are pushing indemnification agreements down on them. And we're starting to see a lot of, anything that goes wrong with that lending transaction, they're looking at our licensees to pretty much cover the bill of the mortgage. Well, so my appraiser that now makes $165 on their appraisal, I don't see how that's equitable to being on the hook for a $300,000 mortgage loan. So just be very careful if you start seeing those, be careful of what you're signing. I don't know what we can do at the division level about indemnification agreements. I mean, that really becomes a regulatory aspect of the people that are requiring those, which would be your lenders, and that's not us.